A will is a legal document that transfers property upon your passing. The document has to be in compliance with the laws of the state in which you reside. And why do you need a will? You need a will so that your property is distributed according to your wishes, so that you know whoever you wish to have taken care of will be taken care of. If you do not have a will, the court decides. The court will not decide to take care of your pets. You can do that in your will. The court will not decide how to distribute your property. They will just make an even distribution across your heirs by law. They won't make sure that your neighbor is taken care of, or they won't take care of your great niece who's very important to you. Court has to follow very strict rules. Creating a will is much easier than you think. First, you have to decide who you want to receive your property. Then you have to decide who you wish to be in charge of distributing your property. That person is the executor, or as known in Maryland, a personal representative. Then you have to make the decision to come in and talk to a lawyer. You don't necessarily have to talk to a lawyer. You can always choose to do it yourself. However, if you choose this route, please know that if you get a form off the internet or from a corporation that does wills across the country, it won't be tailored to your specific needs in your specific state. What are the problems with a will? Should you choose to visit an attorney to discuss how to distribute your property, an attorney will go over with you the difference between a will and a trust. With a trust, you do not have to register your document with the courts. With a will, you have to initiate probate by registering your will, either upon execution or upon your passing. With a trust, your property is transferred to the beneficiaries immediately. There is no contact with the court. There is no coming to the clerk's office. There is no filing fees with the court. Your property is simply distributed in the manner in which you chose. A will also cannot address tax concerns. At Z Family Law, we strongly encourage you to speak to a financial advisor or a tax specialist. And in working with that specialist, we can draft a trust for you, which ensures you are as protected as possible from various taxes. A will is the foundation for your estate plan. However, using exclusively a will as a manner in which to transfer property has some shortcomings. For example, if you have only a will, you're forced to go through probate. That means you have to register your will with the courts, pay a fee, and it can take upwards of 2 to 3 years to receive the property through the will. While a will transfers property, that is all it can do. It cannot address any concerns or problems that may be triggered with the transfer of property in the tax laws. There are other documents, such as a trust, which can be drafted to ensure that the maximum amount of property is transferred to your beneficiaries. When you draft your will, one of the most important decisions is to choose who your executor or personal representative is going to be. And how do you do that? How do you decide who is going to be in charge of distributing your property in accordance with your wishes? You have to look around your family, decide who's the best with paperwork, who's the one that you can rely upon to honor everything that's in the document and follow court procedure. When you make the decision to come and speak to an attorney about your will, what do you need to know, or what do you need to bring with you? It's important to think about who you'd like to name as your personal representative. It's also important to have a working knowledge of your property and your bank accounts. That way we can ensure that all of your property is addressed in either the personal property memorandum or addressed in the documents transferring the bank accounts. After your will is executed, what are some of the common challenges which can occur? Members of your family can challenge the validity of the will. That's why it is important to ensure that your will is executed in compliance with the laws of your state. A spouse or a former spouse can challenge the will if they believe they did not get their fair share. That is why it is critical that your will expressly indicate to whom you wish your property distributed. If you have any questions or concerns about creating a will or having a will and wanting it to be reviewed to make sure it's in compliance with the laws of the state, please contact us. At Z Family Law, we wish to help you create a legacy of love for your family.